Be seated. Okay, thank you all for returning today and returning timely so that we can proceed with the day 2 of the trial. The prosecution has arrested and is the defense calling on the witnesses?
Defense rest, Your Honor. Your Honor, maybe we should have addressed this before the jury came in. I would like to have the defendant hear about his right to testify.
He has the right to remain silent, so.
About his right to remain silent, oftentimes we do a voir dire where he just indicates he understands that it's his choice.
You have to waive silence. He doesn't have to waive testimony. He has to waive silence.
Can we briefly approach?
You may. Mr. Gary, can you raise your right hand? You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury. Can you speak louder?
No.
You can put your hand down. Okay, so you have the absolute right to remain silent. Anything that you say, anything that you put in writing can be used against you. You understand that? Okay. You also have the right to waive your silence, take the stand today, and give testimony and tell your side of the story. Do you understand that?
Yeah.
Okay, and are you willing to remain silent, or did you want to give testimony? No one's forcing you or threatening you to do it, correct? Okay, thank you.
Yeah, people are satisfied. Thank you, Your Honor.
Thank you. You can proceed to your closing argument.
Thank you for bearing with me while I get my ducks in a row here.
Oh, we can't. Only the host can. The host can.
All right. Oftentimes I have a PowerPoint. This time, bear with me while I use my little notes app to get me through this. Thank you all so much for sitting through this jury trial with us and coming back today. It's an inconvenience. We all have lives outside of here. We don't want to give 2 days to this as your civic duty. I really want to thank you for being here. Ultimately, this is a case about entitlement. This is a case about a defendant who believed that he was entitled to go into this building, entitled to do what he wants, go in there without going through security, entitled to barge his way past security, shove his way through, shove people around to get in. That's what this case is about. It's not about de-escalation from these people who just work at this building. It's about this defendant's entitlement. Now, I want you to imagine for a second. All right, remember when you all came into this building, right? When you all were going through security. Imagine if you get outside and you realize, oh, I forgot something, and you run outside and you come right back in. They're gonna wand you again, right? You're gonna have to go to the metal detector again. You think you're gonna be able to just walk right through, get into this building? Of course not. Now imagine next, you decide, I don't wanna go through security. And you start just, I'm gonna skip this metal detector, I'm just gonna go in, okay? And security steps in to intervene, okay? And you decide, no, I'm just gonna push through. I'm just gonna push through. Who do you think is getting in trouble here? You guys think you're gonna be in trouble for that? Or do you think that whoever was in charge of this building is gonna say, you know what? When you were trying to just barge through and get into this building without going through security, Gus, the security man, really, he should have de-escalated. He should have said, you go ahead, but also, excuse me, I don't think that you should be going in when you might have a weapon or drugs or I don't even know. Come on, that's ridiculous. you would be in trouble for having physical contact with that person who's there doing their job because you just barged in past them instead of going through security because you pushed through them. All right. Now, one thing I want you to keep in mind is that the two people who you saw testify yesterday, the two people we are alleging are victims of what we submit as a crime, Garrett and Warren, they're not police officers, right? They are security guards. They are people who were at work, just doing a normal everyday Joe job. Okay, so I don't want you to hold them to the same standards that you would hold a police officer, because that's not what they are. So I don't want you to get it twisted, right? They're not carrying guns and tasers. They were just there working at this community center, making sure the people in the community center were safe and intervening to keep someone from getting in there without going through security. Now, before we get a little closer into what happened, I want to talk a little bit about what beyond a reasonable doubt means. I have to prove beyond a reasonable doubt that what the state of Michigan is saying happened, did happen. All right, that's what that means. That's what, when it's my burden to prove this, that's what that means. What it doesn't mean is that you need to lower the bar for how this man needs to conduct himself in a public setting when entering a public building. That's not what that means. That doesn't mean that you can't scrutinize his actions when you watch those videos. That doesn't mean that you can't think, wow, he shouldn't have behaved that way. Doesn't mean that you have to think, okay, well, maybe they should have de-escalated. Okay, well, maybe he was having a bad day. That's not what beyond a reasonable doubt means. What beyond a reasonable doubt means that I have to prove to you that there was a violent, harmful, or offensive contact intentionally initiated by this man against the will of those two people who testified yesterday. And so I want to make that very clear. And lastly, is I don't want you to hold those two to a higher bar than you're holding this man. All right, I want you to have the same expectations for we're all members of this society, we should all have the same expectations. Even though he has the presumption of innocence and I have the burden of proof, which I'm not trying to shift by any means, that doesn't mean that he has lower expectations of how to conduct himself than the two people who testified. So keep all of that in mind while we get into things in a little bit more detail, okay? Now I'm going to put back up these videos that were the star of yesterday's show. And I'll have it turned this way. You can pick your poison between laptop and monitor. Monitor is bigger, laptop's a little smoother. So you pick your poison. I apologize again for my struggles with Zoom. It's what it is. All right, now this is where we're starting, okay? This is our starting point. Okay, nothing violent is happening. No physical contact has been made. Back this up a little. Look right there. Right here. Okay, obviously these videos don't have any audio, but we do have corroboration because look what he's doing right there. He's pointing to the door. Right there is when he's being told you have to leave. Now, one thing we talked about entitlement already that I need to be clear about is that this man had no right to enter that building. Entering that building was a privilege of his. Okay, he could have walked in and they would have had the right to say, you know what, we don't feel like having you in our building today, turn around and go. They didn't do that, but they would have the right to because he was not entitled to be in that space. He especially was not entitled to be in that space without going through security. So right there, when that man right there pointed at the door and said, you had to leave, he had a legal obligation to leave that building. That's not what he did. Okay, so let's be clear. The first thing that happened is him pointing out and saying, you have to leave. Now, why did he say you have to leave? We have testimony from two people who said it's because this defendant was making threats. Specifically, we have the threat of, I'm gonna beat your asses, right? Now, obviously, I think the defense is gonna say, well, our second witness at first didn't remember what it was, and then when I fed him the words, beat your ass, he did remember, that's what he said, okay? But let me tell you another thing. We had Officer Rotuno up here briefly, and we saw what the defendant had to say about it. And he even says on his own, unprovoked, oh, they were saying I was making threats. They were saying I was making threats. So even he knows that threats are an issue in this case. And I want to be clear that the evidence you saw up here was uncontradicted. There is no evidence disputing that threats were made. All right, I want to be clear about that. Now, the defense attorney arguing, well, we don't actually know that threats were made. That the arguments are not evidence. The evidence we have here is two people sitting there saying threats were made. That's the evidence that you have, and your decision needs to be based on evidence. And the only evidence you have is that threats were made, and him pointing out the door and saying you have to leave corroborates that threats were being made. Now, what happens next? He tries to go around. All right, after he points and said, you have to leave, he tries to go around. Now, is this aggressive right here? Is that aggressive? Sticking his arm out to keep him from entering, to keep the patrons, the lawfully present people in there safe? Is that aggressive right there? Now, one thing I want you to focus on the fact that right now, there doesn't even seem to be any physical contact. This starts, he passively holds out his arm. Okay, now what is a battery? A battery is a violent, harmful, or offensive contact. Now let me ask you this. Garrett Ward, he's doing his job, he's at work. You refuse to go through security. I can't let you in this building. I put my arm out to keep you from going into this building. You bulldoze through my arm. Is that an offensive contact? Is that an offensive contact? By putting his arm out to keep him from entering the building where he has no lawful right to be, for all Garrett knows, he could have a weapon. He could have drugs. I mean, he's not willing to go through security out of nowhere. We have testimony he's been through security many times, and suddenly he doesn't want to go through security. All right, Garrett here has every reason to believe he could have a weapon, could have something he doesn't have. All right, now you put your arm out, keep him from getting in. And then who initiates contact? It is Maurice Gary who does. And I submit to you that it is an offensive contact. I mean, we saw it right there. He starts pushing through. All right, now watch that part right there. Let's go back a second. Look at that. He pushes him back. He pushes off. We talked about this. And push is an assault. All right. He's not facing death row here, guys. All right. We're not in the courtroom down the road with a 14-person panel. All right. I am not saying that this is some serious, life-threatening, egregious assault that should have him tossed in prison for the next 40 years. Okay. So I want you to lower your expectations of what an assault is. I don't need to prove he threw a punch. I need to prove harmful, offensive contact. And that's what that is. He just bulldozed through the arm and then pushed off. Okay, so that's two assaults at this point. Now at this point, Garrett pursues him. Because of course he does. He can't just let him get in. Okay, now the fact that Garrett is pursuing him does not mean that the contact from here is consented to. It does not mean that it's not harmful or offensive. It does not mean that it's not an assault. Now let me take us to the next video. Technology really decides not to work at the worst time. I apologize. I can't get it to work in a second. I'll just move on. All right, my video player has decided it's done working. So I have to ask you to rely and remember what happened. But we remember in the video, they wind up tussling into that back room. Okay, we go off and we can't see them for a second. Okay, and we have testimony about what happens in there. We have testimony about Garrett's knee going out and him going onto the ground. Right now, even if it's described as tussling or pulling or something like that, every single time Mr. Gary tussles, every single time he pulls, he has no right to do that. Okay, Garrett has the right to try and push him out. Garrett has the right to pull on him. Maurice Gary does not have the right to push back, to pull back. He has no right to be here, and Garrett has the right to try and get him out of the building. All right, and then we have a very distinct point in the video where we see Warren standing in the frame while this defendant, while Garrett are still over in the hallway right by the exit. We have testimony, there's a door right there where Maurice Gary could just see himself out. What does he do instead? He initiates contact with Warren. We see him bulldozing Warren back out into the opening area in front of the desk. That right there is battery. That right there is an assault. He, at that point, is one who initiates contact. He is the one who plows in. All right, now we have testimony that he at some point says, oh, I need to go in and get a backpack. I need to go in and get my stuff. We don't even know if that's actually true, but even if it is, we have people offering to get his belongings. And even if they say, yes, I see your stuff right over there, but I'm not going to let you go get it. You're not allowed to go in there and get it. He does not have the right to pull those in. There are other things that he can do to try and get his property. He doesn't have the right to pull those in, put his hands on people, body check people, plow through people. He doesn't get to do that to retrieve his belongings. Now, I do want to go through, I talked about evidence that is uncontradicted. Let's talk about uncontradicted evidence. What do I mean by that? I mean that you have evidence that something happened and you don't have anything to the contrary and your decision is based on the evidence. I talked about the uncontradicted evidence that he made threats. It is undisputed that Garrett points at the door before anyone touches anyone and says, you have to leave. It is undisputed that he then starts trying to push past, that he then initiates contact, he then pushes and tussles and pulls. It is undisputed that then they go into a place where there's an exit where he can leave. There is a time when Garrett's on the ground, Maurice Gary is free, Maurice Gary can simply leave the building. It's undisputed that instead of leaving, he then plows his way back through Warren. There is no dispute on any of that evidence. Even when Maurice Gary talked to the police and gave a statement, he didn't dispute any of that. Now, he did make some statements that did not align with the video. All right, he did say some things that didn't line up with what we saw, which shows consciousness of guilt. He did talk about just on his own, unprompted, I didn't do anything to his name, shows consciousness of guilt. shows he's doing stuff that he knows he's not supposed to be doing. Now, I want to touch on what I anticipate the defense is going to say when they have the chance to do their closing arguments. Any possible defenses, honestly. First off, this is not a self-defense case. I don't think that he's going to argue self-defense because that just would be so absurd. He clearly was not defending himself. So we don't have that argument there. Another defense to assault would be consent. The undisputed evidence is that neither Garrett nor Warren consented to the contact with Mr. Gary. All right. Another argument they could make is that these two failed to de-escalate. Now you're going to get a long set of instructions. Okay. What you're not going to get is an instruction that says an element of assault is that the person assaulted first tried to de-escalate the situation. All right. Where is Maurice Gary trying to de-escalate? Why are we putting the burden to de-escalate on these two people who are just at work, assuming that they were the ones who were not de-escalating? The evidence we have is that he's escalating, he's making threats, he's trying to pull us through. All right, so that's not an element. I don't have to prove beyond a reasonable doubt that these two try to de-escalate the situation. And maybe as to the last resort, Hail Mary pass, they're going to try to get into, well, this was mutual. This was mutual. Okay. Do you have a right to plow through security and push someone back because they're also trying to keep you out of the building? Does that make any sense to you? We have voir dire questions. Well, does there always have to be aggressor, or can it be two aggressors? Can it be mutual? Do you think that this is a two aggressor mutual situation? Or is this a couple of security guards trying to keep a community center safe while someone who decided to be destructive this day tries to bulldoze through them, pushes them around, initiates this physical confrontation that puts people in danger and ultimately causes someone to get hurt? All right. Now, are we also going to hear about, well, what was the real cause of Garrett's injury? And I'm going to describe that as a red herring because this is not charged as aggravated assault. Aggravated assault is an assault causing an injury. Okay. An injury is certainly evidence that there was an assault. I don't have to prove beyond a reasonable doubt that an assault caused an injury. So I cannot even think of any other defense they could try to assert. There's an old saying, the proof is in the pudding. Well, in this case, the proof is in the video. And what I'm going to leave you on is I'm going to ask for you to look at the choices that Maurice Gary made. Look at his choices. Don't put your scrutinization on the people who testified yesterday. I want you to look at this person. This is the person who's on trial. Think about the choices that he made. Watch that video. He made the choice to try and push his way through. He made the choice to wrestle with those two. He made the choice to re-engage and make contact with Warren. He made the choice to make threats. He made the choice to refuse to leave the building, and he was told he was not allowed to. Those are the choices that Maurice Gary made. Maurice Gary is here. Yes, was here yesterday, is here today because of the choices that he made. And I am here asking you to hold him responsible for his choices, his decisions by finding him guilty of both counts. Thank you.
Thank you. Members of the jury, this is a case of a clearly overzealous security team initiating contact with Mr. Gary, getting into his personal space, and failing to de-escalate the situation when Mr. Gary became agitated at the perceived harassment. On this day, there was a clear lack of community at the Kristen Community Center. Now, prosecution is not able to prove their burden for a variety of reasons. One is that there is a clear lack of credibility with the witnesses. Now, let's start with Warren Wright. Now, he initially admitted that he didn't remember any of the statements that Mr. Gary had allegedly made towards him, any of these alleged threats. He stated that he didn't remember to the prosecution. He then initially stated to myself on cross-examination that he did not remember. In fact, he got defensive and asked me if I remembered statements from months ago. Did I remember threats from months ago? Well, I would just say yes. I would. I mean, how many times do you threaten, honestly? Now, all of a sudden, when I state the statement of that Mr. Gary was going to beat his ass, suddenly he remembers. Now, this reeks to me of someone who is covering for a coworker because they knew that their actions were in the wrong. Now, Mr. Wright, first he said that there was no type of conduct policy for how they're supposed to deal with this type of situation. Then he eventually does admit that there is some sort of policy from the contracting company about the de-escalation. Clearly, that policy was not followed, not by him, and clearly not by Mr. Hart, because Mr. Hart claims that there is no policy, that he just operates on a basic policy of love and mutual respect, which clearly he did not follow when he decided to grab Mr. Gary up by the head and neck area when he was attempting to walk past, simply to get his things. Now, Mr. Wright also stated that Mr. Gary was shoving Garrett back. Now, what does this show us? This shows that Garrett himself was the one that initiated the initial physical confrontation, and then a mutual struggle ensued. Now, a mutual struggle, something in which both parties are clearly shoving with each other. When one party, Garrett, initiates this contact, does not show that there's any type of assaultive actions by Mr. Gary. Now, regarding the knee injury, and again, this goes to credibility. I asked Mr. Hart, did he remember giving a statement to police that actually none of Gary's actions caused an injury? I asked him, was it true that he told the police that he had a carotid knee injury and that this is something that he had already been dealing with? Now, he claims that he does not remember giving that statement to police. Now, I think this is dubious at best, because having a chronic knee injury is not something that you forget. Okay, it's either yes, you remember having it, or no, I don't remember having it. You don't forget something that is so chronic that it causes your knee to allegedly pop out of its socket and dislocate. Okay, that's not something that you simply forget. Now, with the video, you saw Garrett, security guard, initiate contact. You can also see Mr. Gary collecting his things from the table before he attempts to walk past. Now, what does this show us? This shows us that Mr. Gary clearly had no issue with emptying his pockets and making sure that there was no suspicion about any contraband being brought in. Now, not to be lost in all of this is that he had already been at the community center and stepped out very, very briefly for a smoke break. Okay. At no point was it necessary to escalate him re-entering the premises in the way that they did. Now, back to Mr. Wright. He talks about how he had seen the incident and that it was very clear that none of Gary's actions caused this alleged knee injury. Okay. First, he says that he just saw him drop during the struggle. Okay. Then later on, he directly contradicts himself. He says he wasn't even paying attention to that and completely recants everything that he said about viewing the actual struggle between Garrett and Mr. Gary. Okay. Now, this shows two things. One, that he actually did not view the situation that like he thought that he did. And two, that he's willing to give inconsistent statements. He's willing to say whatever is needed to make sure that his coworker Garrett looks better. Something else regarding Mr. Wright's credibility is that not only does he not initially not remember that he gave a statement to police that no punches, that Gary did not throw a punch, Gary, or that Mr. Gary did not throw a punch, that Mr. Gary did not try to kick, strike, or in any way lash out physically and strike Garrett or him at all. He initially doesn't remember that. Not only does he not remember that initially, he is refusing to even remember if he even spoke to police that day. Now, think about any times you may have spoken with police. That's not something that you simply forget. You don't forget. You may not remember specifics of a statement sometimes, but to claim that you do not remember giving a statement at all is honestly just ludicrous. These are all things that show just how unreliable of a narrator, of a witness that Mr. Wright was. Now, there's too many inconsistencies for any type of certainty to be met. The burden of reasonable doubt just simply has not been overcome. Hart stated that everyone gets searched, or he first stated that everyone gets searched, and they turned Mr. Gary away because he refused. Then he later said that he turned Mr. Gary away because he supposedly threatened security guards. Which one is it? Who knows? Now, Hart also stated that it was 10 seconds before Mr. Gary allegedly attacked him. Later said it was only 5 seconds until he attacked him. Now, this matters because Mr. Wright is claiming that there was de-escalation involved. How much de-escalation do they really do in 10 seconds or 4 or 5 seconds before Mr. Garrett grabbed him? Initially, when everything was fresh and the incident had just happened, Hart told police that he had a pre-existing knee injury. Today, he couldn't remember, as I stated. Both witnesses are just failing to remember anything that does not favor their version of events. I don't recall. You've heard it many, many times, both witnesses. Mr. Wright said that someone offered to go and grab Mr. Gary's belongings for him. And when asked when that would have happened, he said that Mr. Gary refused to be searched. However, he later said that he didn't have enough time to explain anything to Mr. Gary. So, citizens of the jury, you have multiple prosecutor witnesses here that lack any type of credibility. You have conflicting stories. You have people who cannot remember their statements to police or even if they gave statements to police. Most importantly, this is not a trial about whether Mr. Gary violated Cristo Rey policy, okay? This is a case about, did Mr. Gary purposely assault the security guards? I submit to you that this contact was initiated by security, that the physical confrontation was started by security, and that they chose to escalate the situation rather than de-escalate. I also submit to you that any contact here was merely incidental, as Mr. Gary simply wanted to get his stuff and leave peacefully. And once again, both witnesses stated at no point was there any punch that Mr. Gary threw any punches. They're not claiming that he threw any kicks, slaps, or anything of the like. Garrett, the security guard, simply grabbed him, initiated this confrontation, and a mutual struggle ensued. That is not assault. At most, that is incidental contact. And I submit to you that this should not have been charged as an assault and battery. Disorderly conduct, perhaps, disturbing the peace, maybe. Trespass most appropriately, but not assault and battery. That is a reach of the highest order. Now, let's talk a little bit about reasonable doubt. The burden remains on the prosecutor to prove that Mr. Gary is guilty beyond a reasonable doubt. And your decision as a jury to see if he's met this burden is twofold. First, you have to see if he's met the burden that any assault or battery has occurred. Second, you have to determine beyond a reasonable doubt that this contact was not simply incidental or accidental. Remember, assault cannot be an accident. You have to determine whether there is reasonable doubt as to these accusations. Now, there are issues with credibility of the witnesses. There's issues with the proportionality of the security's actions. There's issues with the fact that security initiated this application in the first place. And there's issues with how both witnesses stated the timelines of how these things occurred. Now, there's just way too many things that the prosecution witnesses were inconsistent on. And the video itself shows that Mr. Gary was not trying to initiate contact. In fact, was trying to walk around them, trying to avoid any type of physical confrontation before that confrontation was initiated on him. This is not someone that is purposely trying to commit an assault. Now, at the end, you have three options, okay? You believe the prosecution's story of events. You believe the prosecution's witnesses. Then that would be guilty. If you do not believe them, that is a not guilty. Most importantly, if you are not sure, you believe that there are enough contradictions within these stories. You are not sure that this video clearly shows a purposeful assault. If you are simply not sure, because your reasonable doubt causes you to not be able to be sure one way or the other, that is a not guilty because of the presumption of innocence, one of the strongest presumptions within the criminal justice system. So at this time, the defense asks you to find Mr. Gary not guilty. Thank you so much.
Now, the defense talked repeatedly about the security initiating contact with Mr. Gary. And I want you all to take a good look at this frame right here of the video. All right, is this initiating contact, or is this passively pulling your arm out when Mr. Gary then continues to move on through and initiate contact? Now, the word grab was used a lot. Is that a grab, or is that an open hand out while this man moves into the arm and tries to hold his through? That's not a grab. Okay, what reason does someone have to misrepresent what you're seeing with your own eyes? For what reason does someone grasp onto things that don't actually matter, like whether or not someone remembers what they said to the police? Stuff like that. It's because you know you've got a loser. Okay, there's no defense here. All right. This is not a grab. This is not being aggressive. This is not initiating contact. Now, another thing I want to touch on is this concept of chronic knee injury. Okay, because who used the word chronic knee injury? That was Mr. Hardy. That was him during the arguments. That was him trying to get Garrett to say the word chronic knee injury. I want you to keep in mind you're going to be instructed that evidence is these videos, evidence is what people who were sitting there in this witness stand said. Mr. Hardy using the term chronic knee injury is not evidence. There is no evidence of a chronic knee injury. I just want to be clear on that. Now, two more points I want to make. One is this being described as incidental contact. again, this is where it starts. Is that incidental? He knows that the only way he's going to keep going to get through is to make contact with this person. And now I want to be clear on the intent element. Okay, even if his intent is to get by him, to go get his stuff, whatever it is he wants to do, he intentionally initiates contact with both of these men in order to affect that goal. So even if it is, I guess, sort of a side action to achieve some greater end, that doesn't mean that it's incidental. That doesn't mean it's not intentional. He intentionally initiates contact when he moves through. I want to be clear on that. Now, finally, there is so much about de-escalation. What de-escalation can you do? He is actively, physically trying to move past you. Okay, what is he supposed to do? Just move out of the way and say, hello, sir, please don't continue moving past security. We're past de-escalation at this point because Maurice Gary has made the choice to decide, he has decided, made the choice that the security rules don't apply to him. He made the choice that even though he's been kicked out of the building, he's not going to leave. And then he made the choice to move past, to bulldoze through. What de-escalation is available to you when someone is trying to force their way past you? So with that, I thank you one more time. Now it's time for the important work for deliberations for reaching a verdict. And I thank you once again, and I ask you to find the defendant guilty of both.
I'm gonna give you a brief recess so that you can go over some final instructions. Before I give you your final instructions, you're not yet ready to deliberate until you get those final jury instructions, but I have to go over some things with the attorneys first. So we're gonna give you about 10-15 minutes. If anybody needed to stretch, get water, use the restroom, get a snack, whatever, and then we'll be back on the record in about 15 minutes. All right, for the jury. Smitty, do you have someone ready to go?
Need an adjournment in my 8:30, yes. Excuse me.
Is the defendant here?
She is, Your Honor.
Where is she? Okay, right there. Okay, this is Zoom Breeze Properties versus Leonardo Torres, Cilantro, Ellen Cilantro, stored as Matias and Taqueria El Chacarito 26-0359. Here, connect to the record, please.
Joy Whitty appearing on behalf of plaintiff, Zumbrin Properties.
Jeffrey Billaby on behalf of the defendant, Your Honor.
And today was the date scheduled for hearing, and she has received counsel and representing.
That is correct, Your Honor.
And did you file an appearance?
Not yet, Your Honor. I was retained yesterday.
Okay.
Yeah.
How much time are you looking for?
If we can have a week, Your Honor.
A week is good enough, Your Honor.
July 15 at 10:15. That's in person at the court. Any additional matters for the record?
No, Your Honor.
Not for plaintiff.
We'll print you a notice in just a moment.
Thank you, Your Honor.
Thank you. Thank you. Ventura Flats versus Kerry Johnson and Lawrence Warwick, 26-03406.
Yeah. Our cases by courts on behalf of plaintiff.
Kerry Johnson and Lawrence Warwick here.
Lawrence Warwick.
You need to come forward, sir. Can you all wait for the people who's going to do their own lieutenant, please? We're on recess. Okay, you are Lawrence Warwick, correct? Okay, today was the date scheduled for hearing. This is for a non-payment of rent. I have here a default judgment as to Kerry Johnson and then consent judgment as to you, Mr. Warwick. Is that correct? Okay, it says that the past due rent to retain possession, $3,765 is due plus court cost, $221.88 for a total $3,986.88. But you'll pay that or you'll vacate the premise in question on or before July 20th, 2026. Is that correct? It states here any payment plan needs to be in writing. So it sounds like there may be a potential of you entering into some payment plan with your landlord, correct? Okay, you understand that you have the right to proceed to a jury trial today? You're going to waive your right to trial. You also have the right to have an attorney represent you. You understand that? You would like to waive that right? Okay, no one's threatening you to do that, correct? Okay. You have 3 business days to return to the court and request to have this set aside. If you later realize you misunderstood your rights, you can return and request to have this set aside and explain how you misunderstood your rights, okay? Any additional matters for the record? Any questions for you?
The motion to stay was denied and my medical stuff doesn't sound
Motion to stay what?
right now.
I don't recall you filing any motion.
We asked about it.
You made a request. We did give you the stay, so we're allowed to give you a stay so that you can get an attorney, which is why we set a pre-trial first, and then we have a hearing at minimum a week later. But I can't give you additional time to hold over somebody else's property because of whatever you got going on personally. So that's between you and the landlord to negotiate, okay? Any additional matters for the record?
No.
You're all set, thank you. This is Cherry Hill versus Cornell Terrace, 2603413.
Good morning, Your Honor. Alex Wilson on behalf of the plaintiff.
Your name, sir?
Cornell Harris.
Okay, today was the date scheduled for the hearing. This is for non-payment of rent. I have a consent judgment. It says the past due rent to retain possession is due in the amount of $6,725 plus court costs, $173.22, for a total due $6,898.22. Is that correct?
Correct.
Is that correct?
Yes.
And that you'll pay that amount in full or you'll vacate the premise on or before the 20th of July, 2026. Is that also accurate?
Yes.
You have the right to be represented by an attorney today. Did you understand that?
Yes.
You want to waive your right to counsel?
Yes.
You also have the right to proceed to have a trial, or you could have held your hearing today. You understand that, right?
Yes, Your Honor.
You want to waive your right to trial? Anyone threatening you to do that?
No.
Any promises to get you to waive your rights? You have 3 business days to return to the court and request to have that set aside. If you later realize that you misunderstood your rights, you can make that motion and explain how you misunderstood your rights, okay?
Yes, Your Honor.
Any additional matters for the record?
None
No,
for
Your
plaintiff, Your Honor.
Thank you. You're all set. We'll get you a copy of your paperwork.
Your Honor.
No problem. Spark Cliff Apartments versus Brandy Harrison and Jacinda Reed. This is 26-3537. Advance.
Morning, Your Honor, Assumption Hart, 69542, capital plaintiff.
Okay, either Brandy Harrison or Jacinda Reed are present.
Correct, Your Honor, I called inside and outside of the courtroom to no avail for either parties, either defendants.
Default judgment will enter.
Thank you, Your Honor.
And this is Holmes Flats versus Savannah Lewis, 26-3532.
Assumption Hart, on behalf of plaintiff.
And what's your name, ma'am? Okay, today was the date scheduled to have a hearing in this, rules for non-payment of rent. If you have a consent judgment, you want judgment to enter by your consent, and you stating that the past due rent to retain possession is due in the amount of $2,045 plus cost of $179.20. And then that makes a total of $2,224.20, correct?
Right, yes.
And that you're gonna either pay that or you'll vacate the premise on or before the 20th of this month, correct?
Yes, ma'am.
You have the right to have an attorney represent you today. You were aware of that, right, correct? You want to waive that right? You also have the right in this matter to proceed to a trial. You could have demanded a jury trial. You recognize that as well? You want to waive that? No one's threatening you to waive these rights, correct? You have 3 business days to return and file a motion to set aside judgment. If you later realize you misunderstood your rights, you can request to have this reinstated, okay? We'll get you a copy of the paperwork in just a moment. Any additional matters for the record?
No, ma'am.
You're all set. Capitol Park versus Kiana Stewart. This is file 26-03471.
Good morning, Your Honor, Rania Haddad for the plaintiff.
Give your name.
Deanna Stewart.
Okay. Today's date that was scheduled for a hearing. This is for non-payment of rent. We have a consent judgment states the past due rent to maintain the premise is due in the amount of $1,559. There's other money due of $178.54. What is that other money for?
There's attorney fees and costs, Your Honor.
Oh, we usually put that in the cost section, but
I've told
no worries.
several times to do that.
Okay, it's for a total amount due $1,737.54. That you will pay that or vacate the premise by July 31st, 2026, correct?
Correct.
Okay, do you understand that you have the right to have an attorney represent you?
Yes.
Are you waiving that right?
Yes.
You also have the right to proceed to trial. You could have made a demand for jury trial. You understand that?
Yes.
And you're waiving that right as well?
Yes.
No one's forcing you to do that, correct?
No.
You have 3 business days to request to have this judgment set aside. If you later realize you misunderstood your rights, you file a motion to set aside judgment and then explain to the court how you misunderstood your rights, okay?
Okay.
Any additional matters for the record, counsel?
Nothing for me.
No, that's it. How are you? Okay, in the middle of the normal 2 months and a trial, and I gotta do a reading today, so. That's a busy Wednesday. You have a minute? Do you solemnly swear or affirm the information you're going to provide is true to the best of your knowledge, information you give? You can sign this and go. Hi, this is Judge Simmons. I'm well, how are you? You have a search warrant? Good morning. How are you? Doing all right. Are you touch your so you swear affirm the information you're going to provide is true to the best of your knowledge and information will be. Sign it to you. Did I send, did you all send me the deposits? I did. Okay, sounds good. This is Carolina Flats versus Angela Behrens and all other occupants. 266-03530, appearance, please.
Good morning, Your Honor. Subject Hart P 69542 on behalf of plaintiff.
Okay, ma'am, state your name, please.
Angela Behrens.
Okay, today is the date scheduled for hearing. This is for termination of tenancy. States here that there's a consent judgment here where they vacate the property on or before the 20th of this month. Is that correct?
Yes.
And you have the right to have an attorney to represent you today. You understood that, right?
I'm sorry. We've come to an agreement of when.
I asked a question.
Yes.
You had a right to have
Yes,
an
I
attorney.
understand that.
Thank you. You understood that, right?
Yes.
Okay, you also had the right to proceed to a trial. You could have made a demand for jury trial. You understand that, right?
Yes.
Okay, you're waiving these rights today, correct?
I believe that is correct.
Okay, you're not sure?
Waiving, I get mixed up, so.
Wait, that means you're given the right away so that you can move forward
Okay,
and
yes.
resolve this yourself without representation and without having a trial, correct? Okay, and no one's forcing or threatening you to do that, correct?
No.
Okay, you have 3 business days to return back to this court. If you later realize you misunderstood what waiving your rights means, you can request to have that set aside, okay?
Okay.
We'll get you a copy of the paperwork. Any additional matters today?
Not for plaintiff, Your Honor. Thank
Thank
you.
you. You're all set.
Thank you, Your Honor. That concludes the court docket for us today. Have a great day.
Thank you. Same to you. You all received the jury instructions for the composites.
Yes,
Okay, do we need to make any changes or updates?
the people have no changes, objections to instructions.
I don't believe I received them, that might be fresh.
It's from Addie with the subject line. Oh, I saw it.
Oh, okay. So,
Ms. Whitty needed something,
No, she got, one of them in German, the other one she has to talk to.
but you only have one more.
She
Oh,
got,
she has two more.
yeah. So the one I believe with Gomez is on German, and that one, they're still talking.
Are they out there?
Yeah, they're all.
I think they can come in and while he
Okay.
catches up.
One instruction that I would request that I'm not seeing in here at least is the missing witness instruction. Is because according to the complaint, there was an officer. What was it? Turbo. That was not called.
I filed a witness list that did not include Officer Turbo. If Mr. Hardy wanted Officer Turbo, I do believe I asked, is there anyone that you want that not on the list? At no point did he say, I want Officer Turbo here. It's a bad faith attempt to get an instruction that just has no applicability. It's just,
Where's your witness list? I see your witness list. It does not have Officer Turbo. And where's your witness list?
My witness list did not include Turbo. I'm mainly going from the complaint showing that he was one of the three of the witnesses listed.
They don't have to subpoena everybody that was on a complaint. You wanted someone subpoenaed, you could have asked. Did you make a request to have Officer Turbo?
I did not.
I mean, this isn't about wanting Officer Turbo to testify. It's about wanting an instruction.
I'm not adding the instruction. Anything else you want?
No.
Mr. Whitty, you just want an adjournment, correct? For Gomez,
I'm sorry, Your Honor, I can't hear
you
you.
just want an adjournment for the Gomez matter?
Yes,
Okay,
legal services will be filing.
are they here today? Okay, we'll just give you,
They're not here.
Okay.
She's out of state and I'm, yeah, sorry.
okay, let's get your new date. July 15th at 10:45. July 15th at 10:45.
July 15, 18, 8:45, I'm sorry.
10:45?
10:45, thank you.
No problem.
Thank you, Your Honor.
We can,
You said the other one, you were adjourning as well, or
I'm sorry.
were you adjourning? the other one, you said?
Yes, both of them.
both of them need
Yeah.
another adjournment.
Yeah.
What's the matter on the other, on LaBelle?
Yeah, what's the matter? She said, what's the matter?
So Shiawassee Holdings versus LaBelle, she has paid in full. We're just waiting for the check to clear.
Okay. Same date and time, July 15th, 10:45.
Thank you.
No problem. Thank you. And then when you do that, you can bring the jury in.
Okay. All rise, jury.
You can be seated, and thank you for your patience. We did have to take care of some little timid matters. And so now we have your final instructions here, if you want to put your attention on the screen. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think that it is. This includes whether you believe what each witness said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles a defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide the case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding this case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something, and that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about December 31st, 2025 in the city of Lansing, County of England. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinion and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix a penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any of the reference documents or the exhibits that have been admitted, including the video, you just ask and we will get it replayed for you, because Mr. Marshmina is going to send it, or Mr. Hardy can pull it up, but they don't have to rely on their memory. You can ask to rewatch it, okay? When you go to the jury room, you will be given a copy of the instructions in written form that you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict for each count of guilty of the alleged crime or not guilty. And we have prepared a verdict form listing the possible verdicts. The council both approved the verdict form, correct?
Yes.
The prosecution has introduced evidence of the statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant didn't make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. And then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Again, the elements for the use of assault and battery. The defendant is charged with the crime of assault and battery. To prove this, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon Garrett Fort. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Garrett Hort's will. It does not matter whether the touching caused an injury. Second, that the defendant intended to either commit a battery upon Garrett Ward or to make Garrett Ward reasonably fear an immediate battery. Same instructions, but as to count 2 for Mr. Warren Wright. First, the defendant, the prosecution must prove beyond a reasonable doubt that first the defendant committed a battery on Warren Wright. Again, a battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant and is not accidental. And it must have been against Warren Wright's will. It does not matter whether the touching caused an injury. And second, that the defendant intended either to commit a battery upon Warren Wright or to make Warren Wright reasonably fear an immediate battery. As used in these instructions, the definition of force and violence means any use of physical force against another person as to harm or embarrass him or her. The definition of touching: for a battery to occur, the touching must have been intended by the defendant, that is not accidental, and it must have been against both Warren Wright and or Garrett Ward's will. It does not matter whether the touching caused an injury. Actual injury, again, is not necessary. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. That concludes our instructions. One of you all will be released for the purposes of being the alternate, and the remaining of you all will be free to deliberate. You're number 7, you're free to go. Okay. Thank you for your service. And she's gonna go down to administration, correct?
Yes.
Yeah. Okay, and then I'm going to swear David in, and then release the jury to deliberate. Remember, you have to choose a 4-person, so that that 4-person can make sure that the deliberations are carried out in a business-like way. And also, if there's going to be any questions, that 4-person will write it down, knock on the door, and he'll be right outside that door if you need it. Just slide the note to him. Raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn to you from separating from each other, and that you will not suffer any communication to be made of them or to them orally or otherwise until the time that a verdict has been delivered? Thank you. All rise for the jury. You may be excused. And recess until they have a question and or anything else. If you need to email that, I don't know how your video.
I was able to, like, I sat down and then I could get.
Maybe it has stage fright.
Clearly.
Like, I sit down and then-
Maybe you need to have IT look at your computer. I don't know.
I mean, IT is looking at my computer later for different reasons.
While they're there, investigate that.
So even if you had an HDMI, that wouldn't work because I plug HDMI into my computer and then it's like no signal.
Ms. Sharp, can you do me a favor and see if Ms. Tolzman is out there? The attorney, Tolzman. Oh, well, I'm ready on yours. Okay, you can, is Mary Sebastian out there?
Yeah, she's coming.
Okay. Waverly Place Apartments versus Mary Sebastian and all other occupants, 26-03728 LT.
Alex Wilson on behalf of the plan.
Okay, Ms. Sebastian, how are you? I'm doing well. Okay, today was the date that was scheduled. This was for a hearing for non-payment of rent it states here that the past due to retain possession is due in the amount of $2,516 plus cost of the amount of $177.04 for a total past due $2,693.04. Is that correct?
Yes,
That's correct, okay. And that you're gonna pay that in full, or you're going to vacate the premise in question on or before the 20th of July, correct, ma'am? Okay, you understand that you have the right to have an attorney represent you? You want to waive that right?
Yes.
You also have the right to proceed to trial. You could have made a demand for a jury trial as well. You understand that?
Yes, Your Honor.
You want to waive your jury trial?
Yes, Your Honor.
No one's forcing or threatening you to do that, correct? So you have 3 business days from today's date to return to the court and request to have this judgment set aside. If you later realize you misunderstood your rights, and then we'll set it for a hearing, okay? No problem. Do you have any questions at this time? Any additional matters for the record?
No, Your Honor.
Thank you. You're all set.
Thank you, Your Honor.
No problem. We'll get you a copy.
I don't know if it's a clean lawyer or something. but-
just gearing up the videos for you all. You can be seated.
About the screen share.
So let me keep,
I'm also able to slow it down if you guys do that.
you can slow it down. Did you want to slow it down?
Yeah, please.
You see that? The other one? Yeah. Smaller on the laptop, but it's also smoother, so it wasn't You want to need the other one again?
Thank you. from our new building.
Yeah.
So if you get selected to do jury trial in the future, you'll be overwhelmed with the amount of space and accommodations. So I do apologize on behalf of Ingham County for the jury room today. This is a very, very good question that was asked. The unfortunate portion is that we're not able to answer the question because it's essentially would cause for some kind of evidence to be brought forth, a question or testimonial evidence. And so what you're allowed to do now is really weigh what evidence you have, and see if that approves beyond a reasonable doubt the defendant's guilt. But this is a valid question. I'm not in a position to answer it for you. I wish I could, okay? Yes.
What if which really cannot come to unanimous decision?
Okay, without telling me any indications. Do you know, like, is it like 50-50, 4-2?
No.
Oh, you don't know that yet?
No. we
Are you
know it
close?
is-
Are you far apart?
Like as far as percentages go, it's like.
Yeah, are you close to
It's
a
like
unanimous,
90-10.
or are you like really like, we're just really like split? It's not gonna happen kind of thing.
We're close to you.
Okay, so this is what we're gonna do. I got something for you here. They love the jail and they ready to use arraignments. Okay, let me hurry. Okay, let's see. Love the jail at noon. There's a lag. My computer never gave me the blue screen a couple minutes ago. So this is not good. Okay, there we go. Okay, jury instruction 3.12, you have returned from deliberations indicating that you believe you cannot reach a verdict. I am going to ask you to please return to the jury room and resume your deliberations in the hope that after further discussion, you will be able to reach a verdict. As you deliberate, please keep in mind the guidelines I gave you earlier. Remember, it is your duty to consult with your fellow jurors and try to reach an agreement if you can do so without violating your own judgment. To return a verdict, you must all agree and the verdict must represent the judgment of each of you. As you deliberate, you should carefully and seriously consider the views of your fellow jurors, talk things over in the spirit of fairness and frankness. Naturally, there will be differences of opinion. You should each not only express your own opinions, but also give the facts and the reasons on which you base it. By reasoning the matter out, jurors can often reach an agreement. If you think it would be helpful, you may submit to the court officer a written list of issues that are dividing or confusing you. It will then be submitted to me. I will attempt to clarify or amplify the instructions in order to assist you in your further deliberations. When you continue your deliberations, do not hesitate to rethink your own views and change your mind if you decide it was wrong. However, none of you should give up your honest beliefs about the weight or effect of evidence only because of what your fellow jurors think or only for the sake of reaching an agreement. So I am going to send you back for a little bit more time. If you're not able to come to an agreement, you'll let me know. If you do have a list of things that could help streamline that I could address, please have your foreperson write it down. Otherwise, if you're not able, I think I'll give you about another hour just because it's gonna warm up in here because it's warming up outside and we don't have good air circulation in here. Nor do I believe that you have good air circulation in the room that you're in. And so I'll give it about another hour and then I'll make a decision. All right. Do we know who's from your office is doing?
Linda Rawls.
Oh, they haven't logged in. The public defender has not logged in yet, and they're bringing me the file, so just one moment, please.
We're generally under the impression that they start at like 1:15.
Well, they start whenever the judge says they start. So I don't,
Well, I'm
I
just,
technically didn't say a time today. They just logged in just now. The jail is logged in, and so, I'm happy, it's only two people. I'm happy
She's
to do
new
that
to
now.
our office, so I'm thinking she'd probably be given instruction around 1:15.
Oh, I'm not sure.
I'll
Wait,
reach
you
out to
said
her.
Linda Ross?
Linda Rawls.
Oh, I know. Linda. Good afternoon. Can you
Good
hear
afternoon.
me?
Yes, I can, Judge Simmons.
Thank you. And the jail is ready. This is the city of Lansing versus Julie Marie Baldwin in 24L284171. Council appearance.
Linda Rawls with the Ingham County Public Defender's Office. Appearing on behalf with Julie Baldwin, who's appearing via Zoom.
Okay, you're Julie M. Baldwin, is that correct?
Yes.
Okay, Ms. Baldwin, I do have a citation here that states that on or about February 8, 2024, at approximately 2:53 p.m. in the area at or near East Saginaw and Fairview in Lansing, Michigan, Ingham County, that you did allegedly fail to display a valid driver's license. That's a misdemeanor, and the maximum penalty is 90 days in jail and or $500 in fines.
Okay.
You understand the charge of the maximum penalty?
I think so.
Okay, it looks like on that date and time, you also received a speeding ticket. It says speeding 1 to 0.5 miles over. That would have defaulted at this point because it looks like you failed to appear twice on this matter. Did she owe money on
Twice?
it? Excuse me?
I just said twice. I didn't realize that.
No. She doesn't know, she doesn't have a speeding?
There is a speeding, it said that
Default.
she paid.
Is it this one? 2472. Okay, it looks like you paid the speeding ticket.
Yeah,
Did she pay that?
probably.
Okay, so look, yeah, it was the same ticket. So the ticket gave you a failure to display license, and then it also gave you a speeding. It looks like you paid the speeding, but you did not appear for arraignment on the misdemeanor. It was waivable, so obviously you could have showed a valid license within a certain time frame to have it waived. Nonetheless, you have the right now to an attorney. You have the right to have a public defender appointed if you can't afford to hire an attorney at the expense of the people.
I have a guardian who is an attorney.
Okay, very good. Okay, so you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. This matter can proceed to trial if you like, because you do have the right to jury trial. You have the right to the presumption that you are innocent. So ma'am, you are innocent until proven guilty, and you have the right to maintain your innocence, take this matter to the next stage and all the way through to a jury trial, and require that the city prove your guilt by proving each element beyond a reasonable doubt. Do you have any questions about those rights?
No. I need to talk to my guardian.
Okay, what is your home address, ma'am?
419 West Fairfield Avenue. Lansing 48906.
Was it 419 you said?
Yes.
Okay, are you employed?
No, I'm on SSI.
What's your phone number?
517-326-9839. But the guy that I called the cops on, his mom pays that, so I don't know if it'll be working.
They did not give me a notice to appear for the court date. Says a pre-trial. Who's the judge of record on this? Buchanan's Judge Ward. Judge Ward? Ward. Oh, Judge Ward. Okay, you have a pre-trial that's scheduled for Judge Ward on September 8th at 9 a.m., okay?
Okay. Am I okay until then? I mean, do I have to worry about getting arrested again before then?
You should not have to worry about getting arrested before then, because I'm going to give you a bond of 200 personal recognizance. So that simply means you do not have to pay anything to get out. The expectation is that you'll follow the court orders and appear to all of your future court dates, okay?
Okay, and
Okay, Ms.
the
Rose,
court date's on this paper, right? Okay, thank you.
Okay, Ms. Rawls, is she requesting that attorney?
She has filled out an application with their office, Your Honor.
No.
Okay,
Oh, that's what you.
The court's gonna note that you are requesting a public defender.
No, I'm not.
You're not
need
requesting a public.
No, my guardian is an attorney. I don't need a public defender. I need my guardian.
Okay, so we'll note that you're declining public defense.
Oh, shit. So that's all I have.
Do you have any questions for the court, ma'am?
No, thank you.
Additional matters for the record, counsel.
No, Your Honor.
Okay, you're all set, ma'am.
Thank you.
You're welcome.
Have I found my going on? I don't remember.
On the record in the matter of the state of Michigan versus Whitney Rice, 25-03766, advance please. Linda Ross log on. Is Janet McDuffie working for you? Counsel? Are you here for a matter?
Your Honor,
Yes.
were you addressing me? I'm sorry.
Yes, counsel.
Yes. I was watching your live stream with Miss Baldwin, and I am her guardian, and I was trying to catch it before you had moved on. She would need a public defender.
Okay, I'll just note that on the record. No worries.
Thank you, Your Honor. Thank you.
No problem. Thank you.
Absolutely. Bye-bye.
Where's it, Linda Roscoe? I'm waiting to have the public defender log back in. I'm assuming she did not speak with Ms. Rice. Is that accurate?
She did. I was advised that she did, Your Honor.
Oh, okay. Well, I don't know what happened.
She's coming.
Ms. Ross, can you hear me?
Yes, I can, Your Honor.
Okay, just after you left, Janet McDuffie did log in. She is, in fact, Ms. Baldwin's guardian. She said that she is going to need a public defender. So you can note that. And then also, I thought your office represented Ms. Rice as well.
Yes, Your Honor, we do.
Okay. We're on the record in the matter of the state of Michigan versus Whitney Rice 25-03766. Can I have your appearance for that record?
Linda Rawls, Assistant Public Defender with the Ingham County Public Defender's Office, appearing on behalf of Whitney Rice, who's appearing via Zoom for her arraignment.
Okay, Ms. Rice is here. There is a domestic violence that she is in bench warrant status on here. Let's see, it looks like she had a pretrial back on March the 3rd, 2026 at 2:30, to which she failed to appear before Judge Buchanan. And then let's see. That was after having a previous failure to appear back on December 29th. And so it also looks like there was a bond violation that was scheduled or should have been scheduled for a hearing also on the 3rd of March that Ms. Rice would have failed to appear. Ms. Rice, did you forget that you had court?
No, I did not, Your Honor. I was not allowed to make that. I was in an abusive situation where I was held down at the floor, not allowed to use the phone, and beat up.
Oh, okay, so you were in, you said a hostage type situation?
Yes, kidnapped, actually. Completely true.
Okay. You were kidnapped by whom, ma'am?
Richard Parmenter, or at least one of them.
You said one of them?
Yes, there's multiple people that go by the same name.
Okay, there's two Richard Parmenters, is what you're saying?
That I know of at least, yeah.
Oh, okay. And back on February 18th, I think I arraigned you. And I gave you a bond of 5,000, 10% with GPS tether. Are you still on tether? Were you still on tether when you were kidnapped?
I don't remember, Your Honor, I don't.
Oh. Okay, well, your matter's going to be reset for a pretrial before Judge Buchanan. It's going to be on July 21st at 9:30 in the morning, okay?
Okay.
Counsel, did you want to address bond?
Yes, Your Honor, we do realize that there was a failure to appear. And so I understand that there may be some concern regarding the defendant's ability to attend the next hearing, but we respectfully ask that the court allow for a 10% bond so that she will be able to have an incentive to appear at the next appearance.
Let's see. Looks like there was a bond there. Supposed to bring bonds. I'm not sure, Ms. Rouse, what level of interaction you had with Ms. Rice. I am familiar with Ms. Rice. I believe I last year had to remand her I believe she was on probation. And it was the same a victim in that case too. But just judging by some of the statements that was made here today, the court actually has a concern about her mental wellness. Not just the statements that was made, but also there is a letter that it appears that she forwarded or mailed to the court as well. So there are some concerns there that I think her attorney would want to flesh out to make sure that an evaluation is not warranted. She has a history of failing to appear. She did have a 10% bond in February with GPS tether, and she can't even tell me if she remembers if she had the tether on at the time that she was allegedly abducted by the victim in the domestic violence case. With that being stated, I don't believe that she is a good candidate for another 10% bond because she's had that with tether, and it was not beneficial. In addition to that, we already have a pending bond violation from February as well. Again, indicating that she violated the no contact order and was in contact with the protected party. And the protected party allegedly called 911 indicating that his girlfriend, Ms. Rice, needed help, which would have been in violation of her bond because she was not supposed to be wherever he lives, works, or goes to school. So with that being stated, a bond at this time is set at 5,000 cash only with GPS tether. She needs to make sure she appears to all of her court dates. I will note that there is the possibility that she may need a psychological evaluation. But I'll leave that for her counsel to speak with her further and determine whether or not additional evaluation is needed. She was at the time, I believe, represented by Ms. Wicks, but I don't know if at this point, we've probably received a motion to withdraw from your office.
I think it's George.
Okay, I do see an appearance from George and Ned from February. I do not see a motion since February to withdraw. So she is represented by your office by Mr. and Ned. And so the violation hearing and the pretrial will go forward on this 21st at 9:30. If you do post bond, Ms. Rice, you are required to appear in court for your next court date, okay?
Good.
You also are not to have contact with Richard Parmeter. Do you understand that?
Yeah.
That would include calls from the jail, which are recorded. You understand that?
I do.
Okay. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. And you're not to travel outside the state unless you get prior approval from the court. Do you have any questions about your bond?
No.
Any additional matters for the record today, counsel?
No, Your Honor.
Okay, you're all set, ma'am. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Ms. Ross.
Thank you, Your Honor.
Thank you. Let's see. Continue to-
I have the, and I got the mom, like,
Yeah.
the mom, that's
Yeah.
talking to you too.
I wasn't standing at the face.
You can be seated. While Mr. Marchvina is gearing up the video, I just want to again reiterate, you all are doing a great job because you're really doing your due diligence, and that's important. That's why the system is set up the way it is. No, I think he's getting good. Is it that? What camera is this? Is it that one? Yeah. Maybe it's the heat index. Maybe it needs to be white. Because it's blurry.
On the,
Why did I do that?
it's gotten a little worse.
You said what? The lag?
Yeah, so it was.
That- it's the
here for
computer.
10 seconds before it finished.
No, it's doing that for me on my computer too.
Excellent bandwidth. If you again want to slow down one more.
I'm good.
Anybody need to slow down? Anyone need a closer view of the laptop region?
Thank you. Guilty of both counts.